right, I think it's going. Hello, good evening, good morning, good evening, everybody. Jessica Miller here. It is 5:30 on, day is it? Thursday, Wednesday, November 3rd. Sorry, just got home from work, and I wanted to do my live video in relation to the fifth jury trial that I ever had. I titled this one, The Jury Trial Involving Math. And I say that tongue-in-cheek because as lawyers, we often say, like, I became a lawyer so I don't have to do math, right? And you might not know that if you're not a lawyer, but a lot of us are kind of adverse to math in general. And, well, there's a lot of lawyers who aren't, but I am. I definitely am. Math is not my strong suit. And so I just tongue-in-cheek said, like, this one involves math, guys. So earlier this week I posted the blog post link to it, but I thought I'd just do an overview as well. This was going back into the DUI arena for me with number 5. This particular DUI happened out at Loafer Creek here in Orrville, and the state parks officer observed the defendant in this case run the stop sign that's at the kiosk when you go into the park. So for those of you who aren't familiar with Loafer Creek, you actually drive quite a ways down into the park before you hit the stop sign, and then you go a ways further to get to the launch ramp or to get to the campgrounds, depending on what you're doing. So in this case, defendant is exiting the campground, he runs the stop sign, and then he does not yield when the officer attempts to pull him over. He gets all the way out of Loafer Creek proper and about 300 feet onto the main road before he eventually stops. He has objective signs of intoxication. He's got red bloodshot eyes. He has an odor of alcohol about him. He admits to 2 beers. Between 11 o'clock p.m. and 12:30 a.m. He's pulled over at 12:56 a.m. They do a PAS, preliminary alcohol screening test, on him 20 minutes after driving, and it shows a 0.09, 0.08. And that's followed up with a chemical test that shows he is an 0.0807 about 49 minutes after driving. Now, this is where the math becomes the issue, guys. So there's a title of regulations, a code of regulations that governs DUI practice. It's called Title 17. And within those titles, those regulations, is a margin of error that is built in for the chemical test, and it's a 0.02%. So with a chemical test of 0.08, 0.07, 49 minutes after driving, it could be that the defendant, if he had a rising BAC, was actually below the legal limit at time of driving. However, in this case, we had the PAS that showed a 0.09, 0.08. So we could show using the PAS and the chemical test that his BAC was on the decline at the time of driving. So in reality, through extrapolation, he was probably realistically a 0.10 at the time of driving. So that's our theory. That's what we're going on. We get to jury trial, and the judge says, nope, I'm not going to allow you to talk about the PAS other than the fact that it showed that there was the presence of alcohol in his system. Now, this was contrary to case law. We have case law on point that says that you can use the PAS results in a DUI case for certain circumstances, such as this, where you have to overcome a rising BAC defense. Judge wasn't having it. Judge didn't allow it. We tried by oral argument, I tried in writing, and then I also tried a third time arguing that the issue of whether the reliability of the PAS went to the weight of the evidence and not necessarily the credibility. The judge still said no. And so without those numbers, our expert could only give us the opinion that the defendant was either a 0.10 at time of driving or he was a 0.06 at the time of driving. He couldn't say with definity one or the other. Now, we had to pivot. And luckily with DUI cases, we tend to charge them in the alternative. So you have an A count and you have a B count. And one is based on driving above the legal limit of 0.08. And another one is impaired driving, shown by your level of intoxication and the level of bad driving that you do. So we just pivoted and we worked on the bad driving with alcohol count. And it was great because my expert, we do these hypothetical questions, and so we asked this hypothetical about that had all the factors that were here, and he said, well, of course he was drunk, look at his driving, it was bad. And the jury ultimately agreed and found him guilty of one of the counts but not the other. And so it worked out. That's one of the reasons why we do alternative charging, so that when cases are brought to the jury and things don't go our way, we do have a fallback position if it's available. There was a couple things about this trial that I learned from the defense attorney that I still use today. And the first one was that when he was cross-examining my officer, he had this giant binder. I mean, it was, I don't know, 8 inches thick, full of stuff, right? And he goes up to the podium, he slams it down, and then he proceeds to open it. And like page by page goes through the Title 17 with my officer, going through all of the things that he didn't necessarily have to do, but that were part of the regulations in general. And I was like, oh, this is great, because the jury sees this physical representation of Title 17, and so I totally stole that from him, and I use that now when I want the jury to understand the volume of information that we have. It usually comes up for me in economic cases. It was great. I used it in a jury trial that I did on workers' comp that I'll talk about later, but we had just boxes of medical records, and so we brought those in. And the important thing, though, is that you not only bring them in, but that you have enough knowledge about the records that you're using so that you can reference them when you need to. And that's what I learned from defense counsel, is not only did he have this giant binder full of the regulations, he could flip to it with ease. He knew his stuff. And the other thing that was pretty funny, and this isn't something I necessarily learned, but this happened after we did the jury trial, after it was either St. Patty's Day or Cesar Chavez Day in Chico, and this was back when whichever holiday that was a big college day, and it was like on a Sunday. And so the defendant was a younger male, and so he comes into court and he's sitting with his defense counsel, and he's just trying to make small talk, and he says to his defense attorney, like, what'd you do this weekend for the holiday? And defense attorney's like, I was working on your case. That's what I did. Which is true. When we have jury trials, we tend to spend weekends. A good rule of thumb for us is for every day of trial, we have 2 days of prep. And so, yes, of course, he was working over the weekend on the case. So this was a good one for me for alternative charging, for putting up, just continuing to fight for what you know is right. Like, to this day, I still think the judge got this one wrong. And it's okay. We just kept moving on. That's why we have judges. They ultimately get to make decisions about the admissibility of evidence, and sometimes things don't go your way, and you just have to be prepared for that. I will put a link in the comments to the blog post on this. I hope that you enjoy it. I have one more scheduled for this week, so we're getting these knocked out. Thanks for listening, and if you have any questions, as always, go ahead and reach out to me. Feel free to like this, share this with people that you think might like it as well. I would greatly appreciate the support. All right, I'll talk to y'all soon. Bye.